Good afternoon. It's 12 o'clock Central by my watch, which means that we will start our webinar on construction litigation in the COVID era. I want to thank all the attendees for signing up. We have over 300 attendees who have signed up so far. The makeup of the attendees is very, very interesting. We have architects, attorneys, contractors, construction managers, government representatives, hospital medical center facilities managers, insurance company consultants, property managers, real estate consultants, school university facilities management. So we're going to have a real lively discussion with this group today. Now, the intent of this forum is to provide information on how COVID-19 pandemic has or could affect and impact existing and future work. This information that will be presented will be based on the experience of our panelists on unique projects and may not be totally applicable to all projects. Again, my name is Ian Shen. I work for Mangini Associates. I'll be the moderator, meaning that I'm going to be the impartial guide as we go through it. A few housekeeping things. This forum is expected to last an hour. We'll try our best to keep it to an hour. There is a chat room, and what we've decided to do is that the attendees should submit their questions in the chat room through using the Q&A tool. And we will address those questions at the time that the subject matter is being discussed. Of course, we'll try to get to all of the questions, but due to time limitations, we may not. Now, the forum is recorded and will be available to view at wje.com webinar library. And as a follow-up after this, all attendees will receive an email as to how to access that recorded forum at a later date. Now, it's my pleasure to introduce our panelists. We have Betsy Manuel. Betsy is a partner in Smith, Bain, Manuel and Horvath law firm in Charlottesville, Virginia. Betsy attended University of Virginia and the Chicago-Kent College of Law. The bar admissions that she holds is Virginia and Illinois, and her practice areas include construction law and litigation, contract negotiations, and insurance coverage. Then we have Matt Mangini, who is an equity partner in McCarthy, Leonard, and Kammerer in St. Louis, but also Matt also works out of the Colorado office as well as the Hawaii office during the wintertime, he tells me. Matt attended Northwestern University and Washington University, and he's a member of the bar in Colorado as well as Missouri, and he's also a mediator arbitrator from the American Bar Association. His practice areas include construction law, construction contract preparations and negotiations, and dispute resolutions. Scott Murphy is a partner in Barnes and Thornburg in Grand Rapids, Michigan. Scott attended Northern Michigan University and Florida State University. He's admitted to the bar in Florida and Michigan. His practice area include alternative dispute resolution, construction litigation, and contract litigation. We thank you all, the panelists, for helping us in this particular forum. And as a matter of transparency, I'd like to point out that WJE has worked with the former firm of Betsy Manuel, with Morin and Barkley, and we have worked with the firm of Matt Mangini and Scott Murphy in the past. So with that introduction in mind, let's get right into the topic of discussion. Today, during the discussion, we will try to use, or the panelists will use, some case studies, obviously without naming the name of the participants, to express their point of view. We're going to start out with pre-COVID contracts and how these contracts were affected by the unexpected COVID-19 that came into the world. So one of the things that was discussed was suspension or delay in projects as a result of the COVID-19. And with that introduction, panelists, you take it away and let the attendees know your experience in this particular area.
Well, I'll say something. So what we're looking at is, as you all know, going back to about March 15th, all of a sudden this became a thing. And probably everybody who were attending now knows that back on March 15th, for the most part in the construction world, at that point, everybody sent out a, hey, COVID's a thing. Don't know what's going to happen, but I'm giving you a courtesy notice that there's possibly going to be a problem. We all did that. Everybody did that. But what then? Three things that I think the panel can talk about, which I'll just frame for a moment. One is you could have a force majeure issue, depending on what actually is happening. You could have a suspension by the owner, maybe, if that's what the owner wants, and we have had that happen. And you could have some interference by authorities having jurisdiction, AHJs, who might issue orders that somehow affect the conduct of a project site. Those three possibilities frame what happens next. And I think the three of us have all had some experience dealing with those things that we want to talk about first. With that, why don't I punt that to Scott and Betsy, let them say some things, and I'll come back in a minute.
Sure, Matt. This is Scott Murphy. Pleasure to be with everyone this afternoon. My experience on the force majeure side of things is that, we've really had a significant amount of projects where obviously have been impacted by the pandemic. And what we found a consistent theme that I have advised all my clients on is diligence. And when I say diligence, I mean typically in every contract, whether it's an AIA contract, consensus docs, whatever contracting documents you're dealing with, it's always going to require specific and timely notice. And so as soon as that that force majeure event comes in, whether it's a pandemic, whether an employee tests positive for COVID, that notice has to get out, and we've drafted a lot of those notices. Most of those occurred obviously back in March and April, but recently when projects have gotten back underway and an employee tests positive, you have to make sure you follow that notice provision, because the contracts will have and carry pretty significant requirements that you provide notice in order to perfect your claim ultimately. If there is an extension of claim time down the road or a request for additional compensation, that notice is going to be a prerequisite to filing that claim. So that's one of the common themes I've seen is making sure you read your contract provisions on extensions of time, and making sure you get that timely notice out and get out in front of it.
So, hi everybody, thanks for having me. So in Virginia, construction essentially was deemed an essential industry. So we had no governmental shutdowns, and projects pretty much have been going full steam ahead. Where I anticipate problems happening with ongoing projects is shutdowns due to positive tests. And insofar as the force majeure clause is concerned, one of the first questions is whether the event was beyond the reasonable control of the contractor. And, I think you have to ask, if you have a positive test, is that something that ultimately is going to be within the control of the contractor or not? I don't have an answer to that question, but I think it's one that has to be asked.
We have a question on the force majeure issue for the panel. The question is, with force majeure events, have you noticed much pushback on the time-only extension versus cost extension?
With regard to that issue, I think all of the panel members emphasize that obviously your force majeure clauses are unique animals to each contract, so there's no overriding answer. What I would say is this: In my experience, to the extent we've been discussing this as a force majeure issue, I've really felt like it has been treated similarly to how we deal with delay claims ordinarily. And it just happens to be COVID related, but the key, as it is with any other delay claim, as Scott was saying, is you got to have the proper notices to substantiate the fact that there really is a delay to the critical path. That always is and has been in the COVID era a key issue. And then, of course, the next question is substantiation as to the damages associated with whatever delay you have. With regard to that, obviously your clause, your force majeure clause, if that's what you're relying on, is going to dictate whether you just get time or you get money. The answer to that is obviously if you have a force majeure clause that has been modified from something like what the AIA has, it may say that you get money. It may say that you get extended general conditions only. It could say a lot of things, but that's probably an obvious answer. What if it don't say anything? If it just gives you time, what do you get then? And what you can take away from that, what we panelists looked at and what I've seen and investigated is there is a topic about that the common law, or in the appropriate circumstances, the UCC may kick in on the subject of what's called commercial impracticability. And commercial impracticability, for those of you who know where to look, the restatement second of contracts 266, restatement second 266.1 covers what that is, and the UCC covers it at section 2-615A, and that fills in the hole that you're asking about. What if my force majeure clause don't say anything about money? That gets you to the point where you would get potentially, if you can prove the delay, an extension of time, and then you would argue that you should get money at common law for that reason. I'll be quiet for a moment, let everybody else chime in before I move on.
Yeah, this is Scott, and I have seen a lot of pushback, especially from my clients that are owners. Compensation for a force majeure event, typically, for example, the AIA documents and the general conditions to the AIA documents, the 201, that doesn't provide for an increase in the contract sum because of a force majeure event. Now, there are other avenues to pursue in order to get additional compensation, but typically what I've seen with most of them, including the consensus docs, AIA docs, is that additional compensation is not part of the equation. It's typically an extension of time when you're dealing specifically with a force majeure event.
Yeah, and from my perspective, it is a hot topic for conversation in contracts that are under negotiation now. So, ultimately contracts are risk shifting devices, and the question I think is really open for discussion: who is going to bear the risk of time extensions and who is going to bear the risk of cost extensions? And is there some, middle ground on those issues? And so I'm seeing that conversation happen a lot on both the owner side and on the contractor side, with no single answer really to the question.
Further to this topic, this question, some other things that you can think about that might answer your question. If you have a GMP contract, it is possible that your contingency clause may cover COVID-related costs. That is a place to look. Again, that's going to be very contract specific. Some are very open-ended and some are not. It's going to depend on what you've actually got there, but it may be an answer to how I can get money if you're looking for money. Another place you can look, possibly, if you've got an AIA contract or something equivalent, which you probably do, there is in there a change in laws topic, which may or may not come into play. If your COVID-related claim is somehow based upon something the AHJ has done, you probably, arguably, have the possibility of making a claim under the change in laws provision, which usually does have a kicker in there that says you get money in time if there's a change in laws. We haven't talked about suspensions yet, but if you actually have an owner suspension note that something is possibly kicking in under a different clause, the owner suspension clause, and that clause usually gets you money if that's what's really going on. One more thing that Betsy brought to our attention yesterday, which I thought was good, a subset is, what about risk of shortages in labor and materials and supplies? Just shortages. Is that covered by your force majeure clause? And I wanted to point out that if you've got a generic one, I think I kind of concluded that the answer was no, that that's not going to be covered either with time or money. Just the simple question of shortages. You probably aren't going to pick that up unless you've had a change to your document.
Correct. And even kind of stepping back another step, I mean, is the cost of preventive measures at a work site a cost of the work under the AIA documents or as modified? Also, the typical AIA documents require a contractor to control the safety programs at the site. Are preventive measures to deal with COVID-19 part of the contractor's obligation for safety, or do we need to, segregate or broaden those provisions to deal with health? Again, I don't have the answer to those questions, but they're ones that would need to be considered when looking at an existing contract or negotiating a future one.
We have a question along those lines, Betsy. And the question is, we, the owner, are experiencing one contractor claiming the owner is responsible for cleaning active construction sites after a positive COVID test and additional cleanings at the site. Do you see this supported in AIA contracts?
So the AIA 201 general conditions of the contract of construction impose upon the contractor the obligation for initiating, maintaining, supervising, et cetera, safety programs at the site. If I were representing the owner on that question, I would assert that the contractor has that obligation. And then the question is, though, is it a cost of the work for which the contractor is entitled to a change?
Yeah, and I would echo that, Betsy. I know Section 10 of the 201 specifically imposes upon the contractor the obligation to quote unquote take reasonable precautions for safety of and shall provide reasonable protection to prevent damage, injury, loss to employees, and et cetera. So I think that you're right. I think the AIA documents clearly impose that obligation on the contractor. So if I was the owner, I think you'd be in a pretty good spot that issue arises.
Yeah, we were talking about this actually in preparation for this meeting. You might want to look, I agree with what the answers have been. You might want to look at the AIA 201 paragraph 3.3.1 or whatever its equivalent is and what your document is. That's the one that talks about manner, means, and methods. And that's all in the lap of the contractor, of course. And in there is a discussion about manner, means, and methods does cover job site safety and procedures for same. So I think that's squarely in the lap of the contractor, and the owner would be correct in saying, hey, this is yours to take care of. Now, is it something recoverable, which is where I think this started. And the only thing I would add to that is it strikes me that is a general conditions. If I had a GMP contract, I'd think that would be covered under my general conditions. And certainly would be a reimbursable cost. Would it be an extra? That gets into the force majeure clause and what that might provide under the circumstances.
Along those lines, Matt, another question came in. Question, can you suspend the project under the typical AIA 101-201 due to force majeure if you don't have a suspension clause? If so, would the contractor only be entitled to a time extension?
Well, first of all, the right to suspend is a creature of contract. And if there is no suspension clause, it's kind of like a termination for convenience clause. If there is no such clause, then I don't think anybody has a right to suspend. Now, from a force majeure standpoint, if there is a suspension, the typical AIA force majeure clause contemplates that the owner might give a directive of some sort, which would delay the project. And if that be the case, obviously you would get time. And on top of that, unless you have a no damages for delay clause in your contract, my interpretation would be the common law kicks in here, and most states will take the position that if the owner does something to obstruct or interfere with the performance of the work, that is a compensable event. That's coming from the common law, not from the contract. And the argument would be, if the contractor was otherwise ready, willing, and able to proceed, okay, the owner interfered, it probably is a compensable event.
And Matt, I know, you know, the 201, the standard terms and conditions under the 201 do allow the owner to suspend for convenience, but inherent in that is, like you pointed out, you can have an increase in the contract sum as well as contract time, and it does say shall be adjusted. So that's a clear right of the contractor in case the owner does exercise that right to suspend for convenience.
And a related issue, and Matt, I think you raised this one in some of our previous communications, where there is a no damages delay provision, they often accept actions that are intentional interference by the owner. And so is an owner suspension intentional interference within the exception to the no damages for delay clause? I have seen contract language that then further defines intentional interference not to include, you know, owner related directives, but, you know, again, it's going to depend on your contract language.
Hey, further to what Betsy just said, I mean, we did look at that and it was kind of interesting. We don't get real legal in what we do, but this concept of intentional interference, we found out that unbelievably, the states are split about 50-50 right down the line about what that really means. Half the states say that there has to be some sort of nefarious element, you know, some sort of, you know, what in criminal law we might call, you know, malice or something. There has to be some nefarious element. The other states say, look, intentional interference is intentional interference. If you did it, you did it. It doesn't matter whether you were good, bad, or ugly. You just did it. Curious that we would have such a thing, but apparently the states are about 50-50 on that. And for the lawyers out there, if you look, I think there's a case from a couple of years ago. I think it's from Connecticut or someplace like that, that somebody wrote like a law review opinion describing all of that stuff. You really got to know. As I'm looking at this, I see a question here about what happens if the COVID keeps the architect from showing up at the site. And that's a damn good question, and it actually might segue a little bit for the panelists here to the next topic of, you know, what about new contracts? What can we say? I'm going to say this to open the topic on that and hand it off. On the new contracts, what I've tried to do is put in a clause that says, look, nobody knows what COVID's going to be. What's going to happen? It could affect both sides, not just the contractor. That's an important concept. Because, as you know, force majeure clauses generally only talk about the contractor. They don't talk about the owner. And one of the things I've been trying to tell everybody is, hey, man, this could affect the owner. And frankly, I didn't think of this question, but this is an excellent question. Because what happens if, you know, for substantial completion, or could be anything, you got to have the architect on site, and maybe he's sick or she's sick, or maybe they can't cross state lines because of some COVID restrictions. The owner is going to need the benefit of a force majeure element in there, which a COVID clause could add for those guys. So
I guess my question would be, does the architect really need to show up on site? So in the city of Charlottesville, Virginia, the building inspector is now doing building inspections virtually. This has been actually one of the great benefits of the COVID experience, because the city of Charlottesville building inspector was incredibly backed up and could not get to their inspections in a timely fashion. So now contractor goes out with a telephone, walks around, the building official tells them what they want to look at, and we're getting a ton of building inspections done that way. So, you know, you could, in theory, it seems, do the same with the architect. Is it as good as the architect being there in person? No, but there are, you know, potential technological workarounds.
But the challenge, though, Betsy, who is going to sign the pay-up?
Hey, further to that
From the
question,
architect.
further to that question, let's assume you just have a standard AIA clause right now, and you're sitting there as the owner, and you can't get your design professional out to the project, and they need to be there for some reason. But you could have the same issue, I suppose, in addressing RFIs or in processing submittals or something. The way the standard AIA is written, it says that your typical thing is going to be, number one, that is something that the owner is responsible for, because it says the owner or those whom it's responsible for, which include the architect. So you would get time, and under the common law, unless you got a no damages for delay clause, you're probably going to get money too.
Now, it seems to me that with all of this, there's going to be a lot of disputes to be resolved later on. What do you guys anticipate going forward, the types of methods that are going to be used to resolve some of these disputes?
Well, I can speak to my experience. You know, I know that there has been a huge uptick in mediations. I've probably got 10 mediations on the books between now and the end of the year, because I think parties recognize that, you know, virtually all the court systems in the U.S., in particular the states that are hard hit with COVID-19, they're behind, and they're way behind. And they're behind in setting hearings, they're behind in setting trials, and I think people are recognizing that. And so, you know, arbitration pursuant to the AAA, you know, rules that specifically deal with construction, or if it's a mediation, that's definitely the way the parties have been moving, especially recently, because, you know, I think everyone's recognizing that if you're going to try to litigate this in court, you're looking at least a year minimum before you get any traction in court. And like, I'm sure everyone who's got in-depth knowledge of construction law, typically these aren't summary judgment type cases, and these are fact issues, and people are usually going to trial to resolve them. So that's been my experience on the ADR side of it, is a lot of people have been pursuing mediation.
Yeah, and I have been recommending that my clients do not select litigation as the form of dispute resolution in their contracts for that very reason. I mean, the courts are just going to be so backed up. I think arbitration is the way to go in any construction contract these days.
What I've been seeing, and pretty uniformly, is everybody, I think, has been keeping a reasonable posture here. We all know that there has been some impacts by COVID, and if you want to get into a strict critical path analysis, it starts getting tricky and hairy and all that. But my experience over the last couple of months is that both sides have been pretty reasonable about it and saying, hey, we know there's been an impact. Let's just try and work it out. You know, maybe it's not 100%, because it probably isn't, but we know there's been something, so let's try and work it out. That is a far better way to proceed than to get into a fight. And I'll just embellish what was just said. I can tell you that basically around the country, to put this in perspective, there have been virtually no jury cases since March 15th. I mean, I know in the St. Louis area, we keep trying to schedule at least one high-profile criminal murder trial, and they can't even do that, because it seems like every time they try and get just one on the schedule, somebody gets sick and they can't do it. So everybody sitting out there thinking about dispute resolution should understand, I don't think it's a year. I think you're talking 3-4 years before you're ever going to get any dispute resolution. And everybody should be saying to themselves, why on earth would I ever want to agree to litigation? Because if I need relief, I'm never going to get it in my lifetime. That's what I've been telling everybody.
So just as a point of reference for the data hounds, Hunt and Andrews Kurth is a Virginia law firm that has a COVID-19 tracker that tracks complaints across the United States. There basically have been 4,000 complaints filed across the United States relating to COVID-19 issues, but only 7 of those are construction cases. So it seems like, you know, construction projects, parties are trying to do something other than litigate COVID-19 issues.
And I know on the arbitration front, actually one of my partners was an arbitrator in a large construction case, and they did it all via Zoom, if you can imagine that. And it lasted about 2 weeks, but I think once they worked out the kinks, they were able to effectively present the evidence in an arbitration via Zoom. And I think we're going to see more of that moving forward. I mean, there's benefits and there's obvious detractions from that, but the benefits are everyone can litigate that from basically anywhere. But then of course you don't have the impact of having that personal experience in front of people. But I think that we're going to see more of that. And I think if you, like you said, if you want to get relief in a year instead of 3 years, and that's definitely the way to go.
Yeah, I have found, oh, sorry, go ahead, Matt.
Well, on that subject, I can just chime in. For those of you who are curious, I mean, for example, I think since March 15th, I've done about 25 days of ADR with mediation and arbitration, and it has worked beautifully. So I would recommend it to everyone. I think it's probably the wave of the future. And I'll simply say this: if you have a smaller mediation or arbitration, let's say you've got 10, 15, 20 documents that you've already shared with each other and the dispute resolution person, you know what? Everybody's got them. You can look at them. You can talk about them. And my experience has been somebody thinks of another document. Okay, you take a second, email it to everybody. Oh, everybody's got it. Everybody's good. On the larger ones, like the one that Scott was talking about, if you've got hundreds of documents, then you have another option, which is to enlist fairly cheaply, I'll say, some IT guy who can help you out. And basically what we did there was, the IT guy put it on a screen just the same way that we'd be sitting in the conference room together and have it up on the screen there. And that was wonderful. You could say, look, I want exhibit 266 and take me to paragraph 3, and the guy blows it up and everybody's happy. So I think it's a good thing.
Yeah, I think Zoom mediations have been very effective. I was resistant to them at first, but I've been in a few now and have found them to be very effective, and agree that it is likely that that will continue as a tool after COVID-19 is done.
We have a question on delays. The question is, what is the best practice for subcontractors to communicate potential delays throughout the construction process? At what point does the law gauge where potential delays turn into actual delays?
Well, as we said earlier, back in March 15th, we all had a flurry of activity, and everybody, subs in general, sent out the heads up email that this is kind of alluding to, and that was a good practice. That basically said, hey, COVID's out there, we don't know what's going to happen, but just being a good guy, letting you know. I think this goes back to what Scott said earlier, though. Regardless of whether you're a general or you're a sub, notice, as it always is critical. More notice is better than no notice. And it doesn't really matter, in my mind, whether you have a contract provision that requires it or not. You better do it anyway, because the fact finder somewhere along the road is going to be much more impressed by somebody who gave timely and proper notice. And certainly you can embellish and substantiate your claim to a great extent the more notice you give. So notice is good, but no notice is bad. That's the answer. I'd be giving it as soon as I know something, and you can always give more than one notice.
Yes, I agree completely.
And on that, a lot of the the AAA documents and a lot of just customized subcontracts, the contractor or the owner will try to impose additional obligations other than just notice, like, substantiating the claim within 21 days, providing estimated costs, impacts, and if applicable, providing a recovery plan or a mitigation plan. So you always kind of want to be on the lookout for that as well, as if there are other obligations in addition to the notice to substantiate the claim. And as Matt said, the more notice, the better. And then it helps you track your claim as well.
Yeah, and a lot of subcontracts are going to require the subcontractor to give notice in the lesser of a fixed number of days or before the GC needs to give notice under the prime contract. So if you're a subcontractor, you're going to have to consider whether prime contract notice provisions are implicated as well.
Thank you. So it seems that we certainly have learned a lot from the experiences of this unexpected COVID thing and the construction process. How do we move forward into the post-COVID projects? How do we utilize the knowledge that we've gained from these experiences in contracts moving forward?
Yeah, I could just chime in here real quick on my perspective. You know, we're in a new era now. Usually the whole concept of a force majeure clause is that there's some event that was not reasonably foreseeable that has triggered relief under the contract. Well, now that the pandemic has already happened and we're entering into new construction contracts, we can't hardly say that it's not reasonably foreseeable that there are going to be delays caused by COVID. So that force majeure clause may no longer apply as to contracts that are entered into in today's world. And so you may have to address that in some customized provisions that deal with the presumption of knowledge and the presumption that there are going to be delays, because you should have known that you are in the COVID-19 era, and so obviously that's not an event that was an event that was reasonably foreseeable. So I think you're going to have to really think about how that's going to impact your contracts moving forward.
Well, there's a bunch of things we can talk about here, and I think this is some good stuff that we're about to talk about. I'll start with one thing and pass it around. Since March 15th, as I said, my general approach has been, because, as Scott has said, COVID is a known thing, I'm not comfortable that a force majeure clause protects everybody properly. Because some would argue that force majeure is meant to only apply to things that aren't known. So I've been adding consistently every week a COVID clause that basically says, hey, COVID, we know it's out there. Both parties know it's there. Both parties don't know what impact might be one, might not be one. We all agree it's there, and we all agree that regardless of which one of us it bothers or affects, we will equitably and reasonably adjust contract time and contract sum to deal with it when and if it happens. And I emphasize again that that is something which the owner needs to be thinking about, because the owner needs protection just as much as the contractor does, because there is a whole litany of things that could happen that will impact the owner's ability to perform. So unlike a lot of other things, this one, the owner does have to care. I will tell you, for the last 3 months, I've had zero pushback on that clause until yesterday, and I had somebody trying to push that risk all onto the general, and we ended up negotiating specific things, which I'll talk about in a minute here, because there are other options you could consider. But Betsy?
Yeah, I mean, I think all contracts have to contemplate COVID-19 moving forward one way or another, whether it is a general, we're going to do what's fair for both sides provision along the lines of what Matt is talking about, or whether you really want to drill down into the specifics of things like our preventive measures of cost of the work. If we have a COVID-19 related delay, are we going to grant time? Are we going to grant money? Are we going to distinguish between the reason for the shutdown? Should a governmental shutdown be treated differently from a shutdown for a positive test on the site? Does it make a difference whether the positive test was for a contractor employee or for an owner representative? I mean, we can go down a gazillion rabbit holes, and depending on whether you are an owner or a contractor or a subcontractor, answers to those questions may be different. So I'm seeing a lot of negotiation of different clauses, not just force majeure, suspension, cost of the work, contingency provisions, caps on exposure. I mean, there's a whole host of things that we are doing in our contracts that, I think everybody needs to think about.
Hey, Betsy, you mentioned the other day that the Virginia Department of Labor passed the first in the nation COVID safety regs. Can you enlighten us on that, please?
I will. And so this is probably something that everybody in the nation should be looking for. So the Virginia Department of Labor and Industry passed emergency temporary standards related to COVID-19 that apply to all employers, not just COVID-19, all employers. And the regulations, 35 pages of regs, I'm happy to give them to anybody who wants them, or a summary if somebody wants a summary of the regs, have administrative requirements, policies about training employees, policies about testing employees, policies about letting employees return to work. There are mandatory vehicular obligations. If you're a contractor, are you going to let two guys get in a truck together? Construction is deemed a medium risk exposure, indoor and outdoor construction. So there's a host of obligations, such as contractors must test their employees in the morning before anybody comes onto the site. They're supposed to have physical distancing and protective barriers. And if you can't have physical distancing or protective barriers, you have to have PPE. What level of PPE? Not clear from the regs. But again, there is significant now regulatory responsibility on all employees, including contractors in the Commonwealth of Virginia. And I think that's probably coming nationwide. And even if it's not coming nationwide, it's things that all project participants should be thinking about.
There's a question related to that, Betsy, where some general contractors are adding COVID contingencies in budget. Is it best to include contingencies in budget or establish an acceptable COVID clause?
So I think you can treat COVID-19 as part of the contingency. I would probably do, if I was representing a contractor, I would do a couple of things. One, I would make preventive measures at the site a cost of the work. And then two, I would probably ask for a contingency to deal with COVID-related delays. But again, it's not one size fits all. I think you're going to have to put together a number of the different provisions to protect your client the best you can, or you if you're not an attorney.
With regard to this topic, contingencies gets back to the question of, they're unique to every contract. I prefer, in my world, to have a contingency that's open-ended, obviously has a not to exceed limit. And that would give the contractor flexibility to deal with COVID, same as anything else. Or you could establish, sub clauses. I mean, like we do sometimes, the tuck pointing has a sub contingency level of whatever. I think that might be, personally, I think that probably be hard to manage for COVID because it's not real clear what's COVID and what isn't. Better to just use the contingency. A related issue is, for example, yesterday, we agreed to, okay, we're going to use the contingency to cover COVID until it's exhausted, if it gets covered at all. And if we go beyond that, agreements were made as to, with regard to materials where we have overruns because of material costs, because we have to replace people who can't comply, or we have labor overruns for that. Here's how we're going to deal with that. 50-50 up to a cap or whatever, you can do that as well. One other thing that you can do, I've had a lot of talk about it, but we haven't done much of it, is establish an allowance for certain things. If you know that you're dealing with a subject matter, you're buying marble from Italy, from Northern Italy, and the odds are you're going to have a problem, you could put an allowance in there, and that's going to protect the contractor. Curiously, though, every time it seems like we talk about that, everybody backs off and just lets it go because obviously the allowance is going to cut both ways.
Yeah.
I'll pass it to you before I keep going.
Yeah, and I kind of echo, Matt and Betsy's position on this. Because the full extent and impact of COVID is really unknown, even today is still unknown. I think the contingency in the budget is a I think if I was negotiating a contract moving forward, I would certainly, make sure that that's included and it's specifically identified.
There's a question that says, when you are referencing a COVID clause, are you implying a clause that addresses any pandemic or just COVID?
Yeah, this is Scott. I mean, usually what our COVID clauses look like, it's this, the standard will say, we'll identify it as a pandemic and then say including but not limited to COVID-19. So it would include COVID-19, obviously specifically reference it, but also any other pandemic is typically the way I've been handling that.
For me, I've just been addressing COVID outright and specifically, but that goes back to what Scott was talking about. The problem we're all concerned about is that COVID is a known thing, and we're worried that a force majeure clause wouldn't address it because it's a known thing. So we figure we better say something about it. By the way, I'm looking at this and I can see somebody asked about public contracts, if we've seen any change in what's going on in that world. So I'll mention that real quick. On the hard bid front, my answer from my perspective is that I'm seeing and looking at as many hard bid contracts as I always have. I have not seen that slowing down whatsoever. Curiously, with regard to hard bid contracts that are out there existing, there's actually been a somewhat unexpected benefit because of COVID, in that a lot of schools, what they did was, obviously, normally they make everybody wait until the summer to do all the work. Well, when they were already closed anyway, they opened up and let the contractor get moving to get things done. So there was actually a sort of an unexpected benefit in that area. I haven't seen in hard bids anybody going over the top, trying to push the risk to the contractor over the last couple of months. I just haven't seen that.
For what I've seen is that for projects that currently have money allocated to them, they're going full steam ahead. Where I've seen the brakes being pumped are projects that are still, a few steps back. They're just in the design process, for example, or no contracts have been let at all. So I do think that for public owners, I mean, given the tax consequences associated with the economic problems we're having right now, there's no question but that public jobs are going to be affected at some point.
One thing I wanted to add to an earlier question, going forward with contracts, I mean, one of our things that at least I always put in for the contractor is, if it's a GMP, for the supervisory clause, the industry documents usually say something about how only for guys on site. And I changed that to don't matter where they're at, as long as they're working on the site. I think I'd emphasized to everyone in the COVID era, now more than before, there is even a greater need to put that in there, because obviously you're going to have a lot of supervisory types who are going to be sitting at home working on the project, and they're not going to be on the site. And you want to make sure that they're properly being compensated for it as a reimbursable cost.
Do you have any comments as to how the insurance companies are responding to all of this?
Very vigorously. I think insurers, I mentioned before that there were 4,000 cases of COVID-related complaints. Almost 1,000 of those are insurance-related cases. And I think for the most part, insurers are denying coverage for anything that's COVID-19 related, with, I think, the limited exception that there may be some civil authority coverage available to some folks, but, little of it would be, I think, available in the construction project.
On this subject, I think we all looked at it a couple of months ago, and the problem is there's not much place for recovery here. You got builder's risk, but that's going to require physical loss or damage to the property. That's a hard case to make. For CGL, you're going to have bodily injury or property damage due to an occurrence. Hard to claim there's an occurrence, much less that there's property damage. And for errors and omissions, you're going to need some kind of a loss caused by the design professional, which doesn't seem like the design professional is responsible for COVID. So as far as I was concerned, I looked at it. I couldn't find anything. That's what I reported. I went out and talked to my friends in the insurance broker world and asked them if I was missing something, and they pretty much said, no, you're not missing anything. So it's a tough road to hoe to try and claim some kind of insurance coverage, as far as I know.
Yeah, I mean, some policyholders have tried to say that the presence of the virus on surfaces qualifies as property damage within the meaning of a CGL policy. I think that's a tough argument to make, particularly since it can be cleaned, but it is an argument that's being made currently.
There's a question that would an inability to find workers for jobs fall under the COVID provisions we have discussed?
Yeah, this is Scott. I do think labor shortages, they're one of your standard typical force majeure events that are called out in the in most people's contracts. So I know that specifically, you know, with a couple of my clients, particularly in the road construction industry, that there have been some labor shortages as a result of COVID, and we certainly have provided notice to the owners and to the governmental authorities that we believe there's at least at a minimum an extension of time that should be afforded for the labor shortage.
On that subject matter, as I said, I'm a little worried that your standard force majeure clause might not pick up shortages. You're getting into an area that's a little tricky there. I mean, certainly one I like to use is much more extensive than that and covers it, but it's a little bit iffy. But the going forward, if you add the COVID clause that the three of us have been talking about, then you are going to pick it up, because you're basically saying, hey, again, we don't know what's going to happen, but if something happens, we're going to treat each other fairly and equitably. And I think if I have a labor shortage for whatever reason happening that obviously nobody can control, that's going to get covered.
Right. The question, though, whether is it something that can be controlled or not, right? What if there's a positive COVID test because there were sloppy COVID preventive measures at a project site? Is that different from, you know, a governmental shutdown or whatever?
What I said yesterday, the analogy I gave, because somebody was saying, well, you know, 3 guys get it. Okay, there's a crew of 20, the 3 guys get it, just replace them. And I said, wait a minute, it don't work like that. You know, 3 of the Cardinals got it, and they had to cancel the games for 2 weeks. The Marlins got it. Not everybody got it. You can't just, it's not just, people aren't interchangeable like that. This is greater than that. Once you've had an impact, it has repercussions far beyond just replacing a couple of guys who happen to get it. So.
Yeah, to that end, Matt, I mean, I had a client, you know, is a construction project down in Arizona involving a large hospital, and literally one worker tested positive for COVID. They suspended the project for a month right off the bat. So as you mentioned, I mean, you can't just replace one worker with someone else. I mean, there are the owners and the GCs, they're reacting very proactively and trying to take, you know, the very extreme step of actually suspending work on the project.
Yeah, so under the Virginia regs that I mentioned previously, if there's a positive COVID person on site, the entire site has to be sanitized, or it needs to sit quiet for a week. Those are the options. And so obviously for a large construction site, sanitizing it, you know, wiping down all surfaces is going to be physically impossible. So in Virginia, you're probably shut down for a week by governmental regulation.
That's going to be a lot of money, Betsy, to do that stuff.
Yeah, it is got to be a lot of money.
So who's going to pay for that?
Right. Circle back. This brings us back to where we started the conversation, I think, right? What does your contract say about who's bearing that type of risk? I don't know, and it's not going to be one size fits all.
One subject matter right on the periphery of this, which I've seen come up, is this, and this involves, I mean, a lot of our projects, you've got maybe they are standalone projects and the owner is not around, but a lot of them are projects where the owner is around. It's a renovation and there's an existing facility right there. The owner has existing operations in progress, or maybe the owner has separate contractors working for the owner right there on top of everybody else. And, the question becomes, how are we going to handle COVID under this situation? And, when I looked at that recently, I was a little worried that general contractors, what is their responsibility for the owner's guys and the owner's separate contractors? My message to everyone is you got to be careful about that. I think that the general contractor needs to make sure that they, under the guise of safety, what we already talked about, the safety clause and the manner, means, and methods clause, that they talk in writing to the owner about that subject and managing the process vis-a-vis the owner. But you got to be careful not to be talking to the separate contractors as well, because if something happens down the road, and who knows what that might be, as with anything else, as far as the personal injury bar is concerned, if you start giving direction to somebody's separate contractor, you're probably getting yourself in the loop now. Inadvertently, you mean well, but unfortunately, the law might get you in the loop. So you got to be careful about following the lines of communication, I think, there to protect yourself.
Have any of your guys' clients experienced any collection challenges during this COVID era?
So yes, is the answer to that. My clients have started to see problems with collection. Again, forecasting, I think it's going to be similar to the downturn that we experienced in 2008, 2009, where collection is going to really become an issue for the construction industry. And so I think when we're talking about contracts moving forward, particular attention needs to be paid to whatever collection remedies are in the construction contracts. It's going to be really important for contractors and subs to pay attention to that.
Yeah, absolutely. What I've told my clients is, this is a time where you've really got to be cognizant of your lien and bond rights and make sure. I mean, the owner could have all the best intentions in the world, but if they don't have the money to pay, they don't have the money to pay. Your only recourse may be that construction lien or bond. So definitely make sure you're familiar with your particular state's laws and what your timing requirements are going forward in the next, year or two.
What I've had happen is, and I think this is good practice for everyone, some major projects, unfortunately, they've reached conclusion. And the owner is in a situation where their livelihood is based upon people coming to their project. It could be many things like a mall or whatever. And obviously they're in a world of hurt right now. Maybe it's getting better now, but they're in a world of hurt. And the discussion's basically been, look, I got an owner in a world of hurt who's going to have some problems making payment. Maybe his lending is tapped out and, we're getting into the final payments here that are based upon the equity that guy's putting in, and he doesn't have any income coming in. Let's all be realistic here. It's worth something to the general contractor to get paid. Maybe you got to take a haircut of some extent to get paid and get done and off the job. And because what are you looking at? If you take a hardball approach, especially if you've got litigation in the background, you're never going to collect, and that's not going to be good. You're going to have subcontractors filing liens, and you'll be fighting with everybody. It'll cost you a fortune. So in my experience, what I've had is everybody's kind of taken a step back and been a little bit more reasonable and shook hands and reached agreements that, took into account these unique circumstances. And then the general then in turn talked to the subs and said, hey, look what I've done for you. I've done something for you here. I got you some money that you might not have got for years. And you didn't want to sit there looking at my pay if paid clause. So, hey, I took a haircut, you give me a haircut. Let's all move on, do well in the next job.
We have a question. Assuming you are working on a site that has a continued operation, like a pharmaceutical plant, and the plant is shut down, partially or fully, due to a construction worker testing positive, is the contractor responsible for damages, loss of revenue? Does it fall under the public liability coverage?
Well, I can try to address that. I think there's a lot of unknowns there, but I think the contractor, I mean, unless, the contractor was acting negligently and was somehow handling of its employees, and this was the result of that, then I think, yeah, they could be held accountable. But typically, I don't think they would. I think a situation where there would be an extension of time granted, and that would be the contractor's remedy.
I guess one question I would have is whether there's a waiver of consequential damages in the contract as well. That could be a problem for the owner if there is one.
Well, sounds to me like the question is what happens, that sounds like the owner is suspending things based on issues that the owner is having with their own forces or their separate contractors. And that just goes back to what we talked about earlier. Seems like that's a force majeure clause typical thing. And unless you got a no damages for delay clause, I think that's a compensable event. As I'm looking at this, somebody's asking if we have any specific thoughts about things we've seen with regard to the AHJ interference, and I'll throw something out to everybody. The answer is yes, and it can happen a couple of ways. The AHJ interference could be direct related to COVID, where somehow the authorities having jurisdiction have done something to limit the work that could be done on a particular project. Perhaps they have, we've seen them enact regulations that restrict people from crossing state lines, for example, from quote hot areas, unquote, to areas that aren't hot. So that could certainly be one. They might have limitations on what you can actually do. I think Betsy was kind of talking about that earlier, what you can actually do on a site. But I think there's some indirect things too, where they may not necessarily say it's COVID, but what happens if, your AHJ site inspectors, because of COVID, they're not coming out on site. They're not coming out and doing inspections, and you're waiting to, whatever your inspection happens to be, maybe it's fireproofing or something like that. You're kind of stuck if you're waiting for them to do it, and that probably is the source of some kind of claim from force majeure standpoint or under the governmental interference standpoint.
And Matt, I'll just chime in on that as well. When I was looking at this issue a couple of months ago, I noticed in the AIA documents there is actually a very draconian provision in there in favor of contractors, and that is if a public authority issues an order and it suspends a project or stops work for 30 consecutive days, the contractor is entitled to not only terminate its contract, but collect all of its profit for work not even performed. And this is in the standard AIA contracts. And I struggled trying to figure out what the rationale was behind that. But that is definitely something everyone should be aware of if you've got, public authority stopping work on a project.
Okay, panel, it's 1:03. Time flies. I'm going to give you 30 seconds each to kind of wrap things up. Go, Matt.
30 seconds. Okay. Well, going forward, I'd say the most important thing I could tell you is to put that COVID clause in your contract. That, regardless of who you are, that's a good clause to have in there to protect you so that whatever comes down the pipe, at least you're going to be fairly and equitably treated. That's probably the most important thing I can say.
Betsy?
And, consistent with what Matt said, I think everybody needs to look closely at their contracts and consider a number of different provisions. And it's really in the interests of all parties to think about these issues and try to find reasonable accommodations on them instead of waiting for a problem to happen.
Scott?
And from my perspective, obviously what Matt and Betsy said are very important. I would add on to that diligence, as I mentioned earlier. Don't just get your initial notice out and then think you're covered, right? You want to continue to be diligent throughout the project and continue to advise the owner of any new developments and how you see the impact really affecting your prosecution of the work.
Well, thank you. Thank you, all the attendees, for attending this forum. We did not get to all of the questions. So what we will do is that we will pose these questions to the panelists and they will respond to you accordingly. I certainly hope that you learned a lot from this forum that you can utilize in your business. And bear in mind that this forum is recorded and all attendees will receive an email from WJE letting you know where and when you can access the recording for viewing at a later date. Betsy, Matt, and Scott, thank you so much for spending time with us, not only today, but in previous days in preparation for this forum. I think it's important and very timely, and the information that you all provided to the attendees today was extremely beneficial. Thank you very much.
You're welcome, Ian. Thank you, everybody. Bye-bye.
Good day.
Thank you, everyone.